Please support Scott Arthur for the petitioner. If I may reserve 5 minutes for rebuttal. Thank you. Petitioner requests this court accept her petition for certiorari, granted, and quash the order under review because Mr. Raines' personal financial information is not necessary to resolve any legally cognizable issue in this case.
Could you clear something up for me?
Of course.
In the record, I apologize for the ignorance, because we try to be as thorough as we can, but the claims, who's correct here? Is it correct that, what's the plaintiff, asserted a claim for loss of support and then disclaimed it verbally in a deposition? Or is it true that that was never asserted? It's not in the complaint.
It was never asserted in the complaint, Your Honor, and we clarified that it was not being.
What is the relief sought? What is the claim?
The claim is for emotional damages, emotional pain and suffering of the surviving daughter for the loss of her father. Period.
It was not an allegation. It was not seeking damages for loss of support.
Not of loss of support and services, not of loss of net accumulations, no economic damages whatsoever have been asserted by the petitioner, and that's been made known numerous occasions. In fact,
the theory that there's joint liability for joint enterprise, would that affect the emotional distress damages that are pled?
No, Your Honor.
Tell me why not.
The emotional distress damages are purely based on the loss of the survivor's father.
But the liability is a factor in this case. Unless you have a single vehicle accident, two friends are together in there, one's driving, one's sleeping.
Correct.
If they have a joint enterprise, they're both liable for the maintenance of the vehicle. Wouldn't the records that they seek show liability for joint expenses? And doesn't the emotional damages pivot off of those issues?
Okay, so if the issue is the liability issues, that would be based on the possibility of a joint venture. A joint venture or joint enterprise doctrines are not legally sufficient. They've never been recognized as affirmative defenses.
Is there any record, any authority for that as a defense to wrongful death cases?
None whatsoever. This court has rejected the concept of a tortfeasor impeding.
It seems like this is a recurring theme throughout the briefing, is where's the authority for the joint enterprise, joint venture in this context of the wrongful death, but you have a negligent driver who apparently fell asleep at the wheel or whatever, and the other gentleman was killed.
Correct.
So is that the sum of your claim?
That's the sum of our claim.
What about contributory negligence?
Contributory negligence was raised as a defense, but it was never argued in support of the banking records, ever.
To say less.
Well, assuming it were, there need to be an evidentiary hearing say, we believe that there may be evidence that, for instance, Mr. Raines was assisting in the maintenance of the vehicle, and that we were therefore looking for any records he may have of payments to repair shops.
And that would, not to make the appellee's argument for them, they're sure the counsel's adequate, but that would reveal what type of negligence on the part of the plaintiff seeking. How would that?
Well, it's tenuous. I mean, but there needed to be an evidentiary hearing. There needed to be an evidentiary hearing saying we have evidence of breakthrough.
Okay, so why do we need an evidentiary hearing? Let's just say, like, well, we want all the financial information, and they could say, here's how it relates to our contributory negligence claim, which is, he didn't secure the load, and somehow these documents are going to show that he had some sort of, control over that.
To the extent that they had a limited theory based on the issues you just described, that would not require over 8 months of every single transaction this individual made since before the truck was even purchased. And we're talking about records that predate the ability of Mr. Bailey, the driver, to be even engaging in interstate commerce before he purchased the truck. There were applications for a personal account that Mr. Raines made in 2013 and 2015 that are contained in these records. They're just vastly overbroad for any discrete issue that the defense might later raise, because again, they've waived any argument that they're relevant to comparative fault, because that was never argued.
Sorry, I said it wrong.
Well, no, I mean, they raise it in their response in this court. They raised for the first time that these records could be potentially relevant to comparative fault, but that was never argued in this precinct.
One question, I don't want to interrupt your flow. Is the test for admissibility or discoverability of evidence of this nature different in a pre-judgment analysis or a post-judgment analysis?
That is one of the distinctions.
And is the discretion with the court greater in which instance?
The discretion is greater in post-judgment proceedings. There are also the discretion.
Well, it depends if it's less. It could be more in a pre-judgment proceeding if it's going to lead to possible discovery, correct? Admissibility.
Correct. The discoverability of personal finances are generally greater in post-judgment proceedings. They're generally
Because the judgment is there.
Correct.
And you're trying to collect.
Correct.
But here, we might be trying to prove liability or other type of damages if the complaint were to be amended, for example.
The complaint does certainly allege negligence, which is, there's a liability issue.
Liability are related.
Right, liability and liability is not what was argued in support of compelling the banking records. It was purely, was there a joint venture? And the theory being, if there was a joint venture, then any negligence of the driver would be imputed to the passenger.
It was a defense, it was just the defenses, not, and pardon my contributor would be North Carolina comparative fault.
Correct, and that would be a defense as well. And
That did not, so I guess that would be a defense as well. But you said something about not liability.
the banking records were never put at issue by any claim made by the estate, by the petitioner.
They're not relevant to you supporting your claim. They're
Correct.
relevant to the defenses, and you point out that the only argument asserted at trial was the defenses of joint venture and joint enterprise, not the defenses of contributory fault.
Correct.
Comparative.
Correct, and it wasn't at trial, there were pre-trial proceedings, there were multiple hearings.
Not trial.
There were multiple trial proceedings, there were hearings.
That's like, of course, we have the tipsy coachman problem, you have the tipsy coachman problem.
Well, sure, there's not a problem for us for the tipsy coach, and there's a problem for the respondent, because you need to have some kind of record in order to be able to establish a tipsy coachman. I mean, these arguments were completely waived.
Well, before you leave that topic, the judgment, the finding of the trial court come presumed correct, come close of presumption. It says a way to affirm that, then we're really bound to affirm that, even if it wasn't argued. So that's the fallacy of what you're asserting. We're not bound by the arguments made.
Not where there's a clear departure of the requirements of law. If there's a clear departure of the requirements of law, in which there's 3 instances of that here, that the incorrectness is presumed. And it is incumbent upon the Court of Appeals then to remand to the trial court to apply the correct legal standard. Now, this court couldn't.
So what are you saying? We should reverse but remand it for the correct legal standard to be applied?
That's our secondary argument. Our primary is that's not even necessary, because again, the sole argument that was raised in the proceedings below to compel the financial records was an affirmative defense that is invalid, that is not a recognized.
So the essential requirements of the law from which there was a departure was the acknowledgement of this defense that is not a defense.
That's the first. The second is the application of the incorrect legal standard.
Remind me what the application of the correct legal standard was?
Yes, Your Honor, the judge applies some net worth legal standard. The judge, the judge's orders.
It doesn't appear that this implicates net worth across the board grant.
Correct, and that's
You're trying to undo that.
correct, Your Honor, and that's.
What we have here is a wrongful death case, all these financial records don't even enter into it.
Absolutely.
But to make a distinction though, so the records don't enter into it because they're not relevant to any defense that's cognizable. But the distinct other standard that was applied is essentially a privacy standard.
Correct.
Privacy extends further than, your protection is not only to protect your net worth, but also other things that could be contained in your business records.
Absolutely, Your Honor.
It's distinct. So let me ask you this, so let's say we presume for the sake of discussion that they can, that if they were to assert a comparative negligence as a, let's presume that actually holds water, that these records can be relevant to a comparative fault defense. Why wouldn't we affirm on discussion?
Because the breadth of the order was so overbroad that there's no possible way that every transaction.
But we're on certiorari.
Right.
That would be irreparable harm. I mean, it's
Right.
not fact, but how's it a departure? If
The departure from the clear requirement as law is the application of the incorrect legal standard, period.
okay,
And if that occurs, then the appellate court is to remand to the trial court to apply the correct legal standard, which the legal standard is all of the financial records are privileged, are protected under the Florida Constitution, Article 1, Section 23.
okay, that's based on the net worth issue. So, but on the other issue, on the inapplicability of the defense for which the party seeking these records believes they're relevant, the departure, I'm saying, what if we find that it holds water and that, yeah, these actually are relative to comparative fault, then that wouldn't be a departure. So the only departure, you're saying it could be a departure because a subset of those records cannot possibly be relevant.
Correct.
In other words, but which kind of goes to the point that you're saying that it's sort of dovetail. So in other words, you're saying at least some of these records cannot possibly be germane to a comparative fault.
Nearly all of them. I mean, honestly, the court
I
would.
think they're not all, but what if we say some?
So if some were, then that's why the evidentiary hearing would be required, so the judge could say, okay, well, look, this line item here could potentially relate to a payment to a truck shop. Arguably, that's relevant. And maybe a handful. I'm not saying that these records actually contain a handful.
There was an in-camera inspection by the trial court.
There was an in-camera inspection applying the incorrect legal standard and the trial court in that in-camera accepted the viability of an invalid defense.
The court only limited to 6-month period.
Over 8 months. Over 8 months of every single transaction this individual made, like through any account that he owned, every deposit, every withdrawal, I'm
How
sorry.
do you put that into words and quantify what's appropriately discoverable and what is not?
What would be quantifiable is only that information which is necessary to resolve an issue and dispute. The law is clear. Rappaport v. Mercantile Bank, the holding, the information, constitutionally protected information must be limited to only that which is necessary to resolve an issue and dispute.
Protective order is still a possibility, correct?
Yes, a protective order.
Ruled out.
A protective order is a possibility, or just the court accepting that the privilege applies to all of financial records. The court didn't do that in the first instance. The court stated that they were merely transactions and dismissed.
It doesn't mean it's admissible either. It just means it's discoverable.
If the standard is met for the discoverability of constitutionally protected financial
You're saying it's
information.
not relevant, but the court found there was sufficient relevancy, even if it's thin.
The court found relevancy using an incorrect standard and an invalid defense. And so it necessarily would be departed for the essential
You want to
requirements
say
of law.
5 minutes, by the way?
It's 5 minutes, yes.
So you get 1 minute left, 6 minutes.
Okay.
I'm asking because I didn't think I asked you to begin with.
Oh, I'm sorry, yeah, 5 minutes, I requested.
Got it.
Okay, okay. And I'm sorry, because
You have 1 minute to go.
Okay.
So you get-
And it cannot be seriously disputed, a judge, that the sole basis argued both in the proceedings below were for a joint venture as it pertains to these records. In fact, in the most recent briefing by the respondent prior to entry of the order at issue, states, and this is supplemental appendix exhibit page 24, or excuse me, 75. Most recently, on July 6, 2023, at the hearing on this defendant's motion for in-camera inspection, a motion to continue the MP, a motion for partial summary judgment hearing, this court held that the records were relevant to this defendant's joint venture affirmative defense and ordered an in-camera inspection of the records to occur. There's at least 9 separate instances in the record where the respondent solely
Now you're at the 5 minutes.
Relied.
Keep going.
just want to finish this thought, solely relied on the joint venture defense to the exclusion of any other in support of these bank records. And for those reasons, the petitioner respectfully requests that the order be quashed.
Save you the whole 5. All right.
May it please the court, Michael Sasser on behalf of the appellee defendant. Your Honor, we believe that certiorari review, certiorari in this case should be denied because the plaintiff cannot show irreparable harm, and the standard, the correct standard, we believe is whether there is any relevant or compelling reason to compel the disclosure of the information at issue. And the court specifically found that in this instance, and that holding comes from Inglis versus Castleberry court for this case.
Well, tell me why, in my way of thinking, why this is relevant when it wasn't claimed as damages related to the pleadings.
So the information is relevant to 3 defenses that were raised: joint enterprise, joint venture, and the comparative fault issues. This court has been, the lower court had been well aware of the dispute. There were only 2 individuals in the truck at the time. They both were along for this over the road trucking venture. Mr. Raines, the petitioner, the decedent, had previously, earlier that month.
Let's presume that the evidence could support joint venture or joint enterprise.
Sure.
So how are they a defense to the negligence action?
Well, the joint enterprise defense, it's codified also in the Supreme Court jury instructions from 2013 that specifically instruct a jury on applying the defense. But it also has not been.
In that context, is that in the context of the plaintiff and the defendant themselves being, is that a third party?
It refers to the claimant and the driver. So it refers to.
So what supports, that could support a joint enterprise between the claimant and the claimant and the driver. But what if
claimant passenger and the driver?
Okay.
I think the verbiage from the instruction. But moreover, and
So
to the question, I'm sorry, the question earlier raised, the joint venture, joint enterprise defenses have been discussed in a number of cases since the passage of tort reform and the comparative fault statute. And while courts have disavowed it, or disallowed it rather, in cases where you've got social passengers, such as a cane where you've got 2 teenage girls, it's inappropriate to apply to a situation involving minors and to a social situation, or to the 3rd DCA case. I think it was the Long case where the gentleman had gone out for a whiskey tasting, again, a social. This case is entirely different. And even in those cases, the courts did not disavow the defense. They said it's not applicable to those facts. And so we think in this case, the defense is applicable to the facts, where you've got 2 gentlemen who are clearly using this truck for a commercial purpose, both individually as well as collectively. They both have responsibility for the operation of maintenance of it. They both have the responsibility for inspecting the brakes, and in fact, in the case of Mr. Raines, who was the CDL holder, whereas my client was a permit holder, he was supposed to be actively observing his driving. And I think admittedly, and unfortunately, he was sleeping in the back of the time. He had started that trip, Mr. Raines had, earlier that day. He was responsible by federal law to oversee the loading.
we understand, I understand the theory of why it was a joint venture. Right, and I also understand the theory of why that could be comparative fault.
Sure.
So one of those, and please pardon my ignorance, one of those 2, joint venture, joint enterprise, I think it's joint venture, if I'm right, applies in a scenario in which a vicarious liability, right? It's used to establish vicarious liability.
That's one way it can be used, yes.
So one of the cases in which it's used not to establish vicarious liability, but essentially as a surrogate for comparative negligence. I mean, is this distinct at all from comparative fault?
It's-
I mean,
Well, I think it is, because, pure application of it would, comparative fault is then you're weighing the fault of the
yeah,
defendant.
so is this just a complete bar?
Well-
So in other words, you're saying, if it's not just a surrogate or some sort of comparative negligence or comparative fault by other means, then you must be saying it's a complete bar.
Well, I believe that's how the case law is
So
construed.
what case is it a complete bar where a driver and his passenger, the passenger of the state or sues the driver or sues the driver of the state, and it's a complete bar because they were enjoying their prize?
Right, well, I think,
Own Biff and Joe's pool service,
sure.
and Biff and Joe are out going on a job. Biff's in the passenger seat, and Joe is drunk, wrecks the car, and Biff can't sue Joe because they both owned an LLC, Biff and Joe's Pool. Is that
Right.
Show me that case.
I think you might have to go back to the Florida Packers case, which we cite, but more recently, I think the 2009 Erickson case involving the father and the son on the catamaran, that is essentially the result in that case.
That was in a third-party issue?
Well, FPL was allowed to assert it, they had sued FPNL for,
Yeah, so it wasn't the son suing the dad for, for his negligent operation of the catamaran, was it?
no, it was not.
So then how does that apply? How does that help your claim, that it's relevant to some sort of, per se, claim that per se, the defense that bars the claim?
Right, that doesn't, I'm sorry.
So in that case, it would not have barred a claim by the son against the father for being drunk and running the catamaran in the ground?
No, I don't know about the being drunk part.
Maybe.
Yeah, I think it would. I think it would, that we would argue that it
Well, but
would.
that's not what the case was about.
Sure, no, it was not.
Okay.
By the way, before you finish, did the trial court rule on Barisco's motion to strike both affirmative defenses?
No, the court did not. In fact, the motion, and this is where I think we got off on the tangent here about how it was raised. The motion for summary judgment was only against joint venture, not against joint enterprise. And the motion, they referred to the most recent briefing and that we didn't bring up comparative fault. That is because the hearing where this all came out and was discussed was at a motion to continue. We filed a motion to continue the hearing on the summary judgment on the joint venture defense only. So everything was geared to, all the argument, all the discussion there was geared to the joint venture defense. It wasn't, it wasn't in.
Is there a problem with you because this would be a deficient record and it would be blazing trails that even the tipsiest coachman could not have traversed?
I don't believe so, because I don't believe tipsy coachman applies in this instance, because the court was well aware. There were extensive
You can
hearings
be tipsy coachman because the court was well aware that you were making a claim
of
that
these.
this is comparative fault and all of these records are really relevant to comparative fault.
No, I think the court was well aware of the claims in this case, that specifically that our position was that Mr. Raines was not an innocent passenger that didn't have a role in the operation, didn't have a role in the driving of the truck. So any evidence, whether it goes to the joint venture, joint enterprise, or comparative fault defense, it's all part of the same bag. It's a distinguishing between the jury of the proper responsibility of the two men. And isn't it a much more attractive argument to be able to walk in and say, oh, he had no interest in the venture, he was just along for the ride, versus if the evidence shows, oh no, he was earning income from this. This was part of the job. He had an active responsibility to check the brakes and maintain this and that. He wasn't just there along for the ride. So the evidence that we would obtain arguably from this very limited set of financial documents would go to those issues. To prove
somehow, so it would go. So I understand how the evidence would support a joint venture or joint enterprise. How would it, if we presume that there's not I guess that either it doesn't have to be supported by tipsy coachman or that there's evidence that supports the implementation of the tipsy coachman doctrine, how do you address the appellant's argument that all this financial information is not relevant at all to the theory of comparative fault. How does the bank records, all the particularities of the transactions made in Mr. Raines' bank account prove that he contributed, I'm sorry, I mixed them up, we have North Carolina, Florida, just whatever, contributed comparative. How's it relevant to prove the defense?
We can't know that. The judge knows that. She reviewed the records in that context. This court
come up with a theory in order for us to get past
if
privacy rights.
Well, if hypothetically, and again, the court did this analysis. The court looked at the records through that lens. This court hasn't. I haven't.
Let me interrupt there for a second. Your problem with this line of questioning is you're saying the court did the analysis, but it wasn't even mentioned. Comparative fault wasn't even mentioned. So I'm asking you right now to come up with your theory of relevance to comparative fault. Well, I get it. We presume the court did the analysis as to the venture, the enterprise.
Again, the court was well familiar with all the comparative issues. The court spent an exhaustive amount of time, and I'm sure your honors have read the transcripts. The court was very diligent in its responsibilities. And so if those banking records show that he was paying for repairs or that he was receiving income from the business, that the extent to which he was involved in the business, the maintenance of the truck, the operation of the truck, all would go to comparative fault. May it also go to, I'm sorry? How would his role in maintaining the truck, I'm sorry?
Can you explain the theory of relevance?
Sure. The more that a person is involved in the safety of a truck, by the way, this court's not adjudicating how this accident happened, but the driver went off the side of the highway. He didn't fall asleep. He wasn't speeding. The truck was out of control. Evidently, the brakes weren't working because he had the wherewithal to go off the side on one of the off-road ramps. So there was at a minimum evidence of some issue with regard to the maintenance of the truck. So any evidence which would...
Could have been the speed of the truck, couldn't navigate the road and went off on the speed ramp, and then those steel cylinders slid from the top of the truck, and that's what drove him to death.
Right, that's right. And so then we get into the other issues of again...
Could you with more particularity describe what is potentially in the business records that prove that the decedent who was sleeping was comparatively at fault?
Well, again, we think that any evidence which would show his active involvement in the operation is evidence that would go toward his comparative fault. So whether that is in the form of payments for services to the truck, whether that is even in the form of payments to himself, any evidence that shows him as not simply a mere passenger.
If he was being paid, that would turn the tide on the comparative fault.
It'd be evidence of it. I mean, I'm not saying it's anything's conclusive. I'm saying this evidence would go to multiple issues in the case.
Because of established responsibilities?
Yes, and both voluntary actions and other legal responsibilities under either the CFR or under the Florida statute.
Last question, and I hate to interrupt you, but if the trial court did not rule on the motions to strike the affirmative defenses, how can it be a clear departure of law by allowing the discovery to prove the defenses?
The court denied their summary judgment on the joint venture defense, and I'm sorry if I'm not following your.
No, what I'm saying, how can it be a clear departure of the essential requirements of law if the court didn't rule on the two affirmative defenses and say they're totally irrelevant? Isn't that a factual determination?
Well, that's exactly right. So the court, and I think in the first instance, the court's got to be the arbiter of that, which is why, and I didn't press the issue too much because I don't think it was an appropriate issue to press with this court, but I don't know that it's necessarily this court's role to make those determinations to strike defenses out entirely. Right. And so as to the essential requirements of law, again, we're talking about something that is far beyond legal error, an abuse of judicial power.
Let me ask you this. So is this like, so let's say that we find that, let's say you asserted laches or something as a defense. And then they said, well, we need summary judgment on this, this is silly, laches doesn't apply. And then the court got that wrong. And then said, summary judgment denied, their laches defense stands, they can still go forward with it, and they get all this discovery that proves laches that is relevant. You're saying we can't get to that because of the incorrect, even if we find that the motion for some, denial of motions for summary judgment on the defendant's laches, which is patently absurd, we cannot bootstrap that as a departure from the essential requirements of law in a discovery dispute about relevant evidence, because, hey, that's water on the bridge, you made this patently absurd, decision to let this patently inapplicable.
I agree with you 100% there. I think, yeah, of course. But in your example, it's a patently unacceptable, clearly established doctrine of law that this cannot be relevant to.
But on the other hand, we're up here on the issue, right? So in other words, how does a incorrect ruling, if we indeed agree that the trial court incorrectly denied their motion for summary judgment on the defense of vicarious joint venture, how does that insulate another incorrect ruling by allowing in discovery that is relevant to a defense that is not cognizable, if we were to accept the arguments not cognizable?
Well, the court's order says that the discovery that she observed in camera, line by line, in meticulous detail, that it was, she found that it was relevant to the claims and the defenses raised in the case. Okay, so I'm not going to read into her mind as to what exactly she meant by that. I do know that
talking about the fact that you're saying that because that's water under the bridge that this defense was allowed in, therefore it can't possibly be a departure. It can't possibly be a departure from the essential requirements of the law to allow discovery on a defense that's not cognizable. If we find it's legally speaking not cognizable, it doesn't matter because.
No, I think Your Honor's point is correct. I mean, if that is your ultimate finding, that this discovery can only go to that defense, and that defense is no longer recognized in Florida, and to the extent it has been, and even regardless of the factual scenario, we're saying a bright line rule. I think you're correct, but I don't think that's a factual circumstance.
Wait a minute, I'm sorry. Correct that it would be a departure?
No.
Even though that defense had already been adjudicated incorrectly as cognizable?
I'm sorry, I'm not sure. I think I was agreeing with your.
Okay, so I was playing the devil's advocate, but I think you decided that the devil's advocacy was correct, which is that because if we decide that the adjudication of whether defense A is cognizable as to this claim, and it's been adjudicated, you're saying because it's already been adjudicated and subsequently there's a discovery order that's premised on that defense, we can't reach that on certiorari because it can't possibly be a departure from essential requirements of the law because, hey, the judge said that defense is kosher, therefore you get the discovery.
No, I think, and I agree with your example, where if you've got a completely invalid, unrecognizable defense that has somehow made its way through and got to this court would be entirely permitted to say, yeah, yes, yeah.
Sorry about that.
Yeah, I was only distinguishing the facts of this case in this particular instance. Okay. And the court's specific findings in this case, that the information that she saw with her own eyes was relevant to the claims and defenses that were being litigated in the case. She didn't specify any affirmative defense. She didn't say what aspect, and maybe she would have violated some privilege if she would have disclosed too much in that order and somehow affected this court's ability to review. The other thing I wanted to comment real quickly on the form of the proceeding, because I'm not so sure. The purpose of an evidentiary hearing in this case is to determine the relevance of the information, the discovery, the banking records in this case, to the issues. That's the purpose. When you look at Roe and why they were talking about if you conduct an evidentiary hearing, that's what they're looking at, and that's exactly what the court did. She examined the information in relation to the claims and defenses that were before her. Secondly, as I think as the Elser case that I noticed that, an evidentiary hearing is not always required. In fact, not required in their view at all in these circumstances. So we don't know that, number one, that she was required to conduct an evidentiary hearing in this case. But secondly, I think that's exactly what she did. She looked at the evidence before her. She knew what the claims were and defenses because they had been argued ad nauseum during the course of a number of hearings, and the transcripts will reflect that. So we would respectfully request that the court deny certiorari relief in this matter. It's a very limited number of documents, a very limited time period that we're talking about. I actually think it was 6 months of records. I think she might have permitted 8 months, but the actual amount of documents was.
What if we find that the 6 months, the scope is incorrect? So in other words, what if we find, we talked about, you know, well, not Trevor Mentor. We talked about with the appellant that, you know, what if the trial court did not depart from the central premise of the law with regard to whether a defense was cognizable to this cause of action, but some of the records are patently irrelevant because of their time period of the records themselves.
Before you answer, you're technically out of time, but of course, I'll let you finish the answer.
Sure. So, you know, I think we're really only talking about a 3 or 4 month period before this accident anyway, but they did not differentiate. In the privilege log that was filed, they did not differentiate. Every objection was based on privacy, and they did cite the Florida's Constitution. So there was no differentiation.
But they made a relevance argument.
Yeah, yes, that's true. But the purpose of the in-camera was to evaluate their, you know, they submitted a privilege log at the request, and that's what the board was looking at. I mean, in the context of discoverability of the records.
Thank you very much.
Thank you.
You have 4 minutes for rebuttal.
Thank you. Thank you. I want to address one of the most fundamental aspects of this issue is that this court absolutely can correct an incorrect ruling of law by the trial court as it pertains to the validity of a defense or the validity of an element of a defense that serves as the basis for compelling financial records. And this court
Has an argument with that, by the way.
Okay.
Our debate was if the trial court had discretion to do something, how can we overturn discretion? That's discretionary call.
Okay. Regarding joint enterprise, that theory was not argued in the proceedings below as a basis to compel the records. Joint enterprise, that the law is clear in that on that defense as well, is that it can only be used in a third-party context as a defense if it's still even a viable defense in auto negligence claims. I know it's used in the catamaran instance, but in auto negligence, it's pragmatically difficult to see how a passenger could have joint control over the vehicle. But be that as it may, the public policy implications from imputing a tortfeasor's negligence onto the person they hurt have been discredited for over half a century. In Rollison v. Hicks in North Carolina, it would have offend justice and right to impute the negligence of a servant to his master and thus exempt him from the consequences of his own wrongdoing. Hale v. Adams, the first DCA in 1960. A defendant should not be permitted to defeat an action on the ground that he was guilty of wrongdoing. That's exactly what they're trying to do in this instance. And that has been rejected for over half a century.
It seems to me as if this is like the lower court judge may well find that these records are pertinent to a joint enterprise, joint venture. I have yet to see why that matters. What does that have to do with anything? I mean, I'm an old insurance lawyer, so I'm reaching back, but I don't understand.
A joint enterprise, you're right. A joint enterprise is a non-business venture. A joint enterprise factually wouldn't even implicate banking records. And I think the argument they stated in the response was, well, it may tend to show that the joint enterprise defense doesn't apply. So there you have it. Regarding joint venture, you know, factually, the banking records, even accepting it as a defense, it has 5 very specific elements, none of which could be proved by Mr. Bailey's or Mr. Raines' banking records. We don't even know what there's an element, for instance, of joint proprietary interest in the subject matter of the venture. It was undisputed in this case that Mr. Bailey solely owned the truck. That was the only asset of the trucking venture. was the truck. Undisputed, he solely owned it. That in and of itself destroys factually.
Well, the asset, there's a tangible assets there, a team of drivers.
That's labor. That's labor. The asset of the venture is what are its tangible assets? There's the truck. There's the policy of insurance potentially, but that was solely paid for by Mr. Bailey. He was the sole named insured. And it would be impossible to determine what entries could even be relevant to the ability to share in profits. There wasn't even evidence as to what the profits of the company were. The respondents didn't produce their own decedent's banking records in this case, which is baffling since they're the ones that put this arguable, relevant issue of joint venture, and they wouldn't even produce their own banking records to reflect any payments between the two decedents, which, by the way, but the court did make an oral ruling at one of the hearings requesting if either of you have any information in either banking records that show payment from one decedent to the other, I want you to disclose that in 10 days. We responded to that and said there are none. And that has never been disputed. That was not addressed in the court's in-camera review.
You're out of time. I hope
Thank
you're
you.
looking to say something else. Okay, have a nice day.
Thank you very much.
Thank you.
Thank you.
All rise.